And that's
All right, everybody, we're gonna get started. Yeah. So we're gonna start. So that's just kind of the broad overview. We're gonna now talk about creation and function of both bodies, and kind of touch on function a little bit, but just to go over, it's always good to, as a reminder, both bodies consist of 5 members and 2 alternates. The regular members have 5-year terms. Every year, somebody should be up for appointment. If that's not happening, you screwed up somewhere along the line. Try to figure it out and get back on schedule. Typically, where I see that is where somebody leaves and there's like an appointment to an unexpired term, and then, and then they just put in for that 5-year term, not the unexpired term, and the schedule gets screwed up. And so just be aware of that. Alternates, there is no term established by statute. So the trustees should be, when they appointing alternates, they better be putting in a term, right? We don't want alternates for life, like the Supreme Court justices. So make sure they're putting in a term. The other thing that's interesting about the statute, and I get this question a lot, is when do alternates sit? The statute says the trustees decide when alternates sit. I've often found that the appointing resolutions sometimes are silent with respect to that. So, if the trustees have dictated when the alternate sits, you follow that. If they haven't, what I would do is try to come up. Both entities are responsible for having rules of procedure. You're required by statute to have rules of procedure. If you don't have them, get a hold of somebody, get a hold of Scott, get a hold of Chris. Plenty of places have them here in Delaware County. Have your rules dictate when that individual sits. So let's take BZA. My preference, again, this is one of those areas where you may do it differently, and if you haven't been sued yet, that's fine. That when an alternate sits, that alternate should stay with that application until it's concluded for the BZA. That's just kind of my take. Now, if somebody said, "Hey, Pete, we didn't do a whole lot. The regular member wants to sit at this, we continue the hearing, wants to hit at the second one, sit at the second one." What I would say, okay, what I want that individual to do is to read the meeting minutes, read the transcript, familiarize themselves with the record of the first part of the hearing. On the record, say, Mr. Chairman, I just want to make you aware that, the alternate sat last meeting. Now I'm sitting and I familiarized myself with the previous record and I'm set to go. Right? Part of what we do as attorneys is we try to remove as many roadblocks as possible when you get sued. Because if you haven't gotten sued, you will eventually. Something's going to happen. We do not want to be arguing over that issue, right? Because opposing counsel will do everything in their power to make the case everything other than the facts of the case. So they're going to argue it was the Sunshine Law violation. They're going to make public record violations. They're going to talk about BZA members being biased or obtaining evidence outside the hearing or everything they can do. And Chris and I have been there a million times, and it stinks, right? So just that little thing, I think you're okay doing it, but have a rule for it and follow your rule, right? Yes, ma'am.
We asked the applicant if they were okay with the board member sitting in place of the alternate, if they would switch, if the applicant was okay with them sitting on the board before we,
And they probably always say yes, right?
and they always say yes.
What would you do if they said no?
We would have the alternate stay.
Okay, yeah, you can.
But does
And I
that
guess,
eliminate
that
the,
argument would be waived then by the applicant, if they were to appeal it, that may not be a bad thing, but, you can do that, absolutely, but I don't think it's necessary, but you can do it.
What about a situation where, the applicant comes in for the start of, a proposal and a board member is on, and then it's tabled to another date, and that board member is absent that day, then should an alternate join, or?
Yes,
Yes.
yes, and again, same situation, I think the alternate familiarizes themselves with the record and makes the statement, absolutely. Yeah, because we've all been there, where, people are on vacation and we don't have, maybe we don't have an alternate, or maybe we have one alternate, maybe we dip below the full body, right? Maybe we only have 4 members that are present. What's everybody do if you only have 4 members? Everybody should do the same thing. I want to hear if anybody's doing it. I have 4 members present.
It's a quorum, so it should be legal.
It's quorum, it's legal, but what's the first thing out of your mouth before you start the hearing to the applicants that are in front of you? Let them know, because more than likely, I've seen most of your rules of procedure. Do you require 3 affirmative votes?
Right.
In order for an application to pass? So I make the applicant aware that you have to have 3 of 4 votes. If you have a full body, you only need 3 of 5. Do you wish to proceed? So kind of along the same lines you raised with the alternate say. If the applicant says, yes, I'd like to proceed, then they waive the argument. But I've had cases where they haven't been successful because the judges have ruled on the merits, but that argument has been made that nobody told me. I didn't have a full body. I had to have a supermajority. I had to have 3 out of 4. If I had 5, I don't know. Maybe, in fact, maybe it plays out differently. So just be aware of that. The last thing, because I gave this BZA seminar on the eastern side of the state not too long ago, and they've had a lot of annexation. And I said, everybody who's on the BZA is a member of the unincorporated area, right? And I saw one guy kind of doing this. And he was actually in the annexed portion of the township. He was in the, I call it the expedited 2 area, right? Where, you can have someone you can live in both the township and the city. But for zoning purposes, you got to be in the unincorporated area. So just make sure if you're not, then you need to tell somebody. So, function, BZA, again, we talked about quasi-judicial. So what does that mean? It means you're acting like a judge, but it also kind of gives you some key indications. It means that your decisions are appealable. Direct appeal to the Court of Common Pleas. And you may hear an attorney refer to it as a 2506 appeal. And the reason it's called a 2506 appeal because there's a statute that says that's a letter of 2506. That's what we follow. Direct appeal to the Court of Common Pleas, your decision. It's going to tell me that as a member, I should not be having what I'm going to call ex parte communication with applicants or witnesses. Everything that you do, all your conversations, say maybe a question with the zoning inspector, needs to be on the record. All the evidence you hear, all the conversations you have with an applicant, with property owners, needs to be on the record. You cannot have conversations with those individuals outside the record, outside the hearing context. Think of a judge who sits in criminal trial. I mean, is he having a conversation with the prosecutor outside of that, or the defense counsel, or a witness? Well, if he does, he's gonna get in trouble. So, no outside conversation. The third thing it tells me is that I have to run my hearing like a civil trial. Right? Civil rules of procedure don't apply to you, but you need to run them. You need to run it like a trial. And again, this goes back to my point that, look, I understand there are situations where you have the nice elderly lady next door, and she's just simply coming in. She wants to put a new deck on, and it's only 2 feet into the side yard setback, and I get that. I'm not telling you to, run her through the ringer. But I want to give you enough information that when you feel that you have to be able to act and conduct it like a civil trial, that you can't. That radar should go up. You should be calling legal counsel if you have a feeling. And if you get caught off guard, always feel free to continue the hearing, okay? And make sure you get a hold of counsel to come in and make sure you're doing things right. So, but run it like a civil trial when you need to. The last thing that it tells me is that as a BZA member, I can engage in private deliberations. Do not call it an executive session. It is not an executive session. Please don't call it an executive session. Because as soon as you utter those words, it confuses judges. They're going to go to the Open Meetings Act. And they're going to be looking, well, I don't see where the BZA has the ability. It's not in the Sunshine Law, but you can do it. And where it comes from is a long line of cases all the way up to the Supreme Court, where they've said that quasi-judicial governmental bodies have the ability to deliberate in private. And a couple of key points for those that, for people that may question that, is everybody aware of what they call the yellow book that the Attorney General puts out? It's the Sunshine Law and Open Meetings Act. It's now in there. They have a statement in there. The Ohio Supreme Court has determined that public bodies conducting quasi-judicial hearings may require privacy to deliberate. Okay, it's in there. And then the first time that it happened in the state was out of Liberty Township years ago, here in Delaware County, where the BZA went into private deliberations, came out, denied the application, got the court. They argued a violation of the Sunshine Law and went up to the Court of Appeals. The court said, no, they're allowed to do that. So here's the motion. Motion to recess into private deliberations for the purpose of considering the merits of the application. Second vote. You all go back into a separate room. You all powwow. Right? Now, you don't take a formal vote, right? Because that's got to be on the record. But that purpose of that is try to reach some consensus of what you're going to do with that application. Talk about what other evidence I may need. Hey, maybe we need to call this person back up because I'm not sure that they're telling us the whole truth. Or I would have liked to ask this question. Call the witness back up. You can even scratch out. I mean, if you have, an outline or a form with the Duncan factors on it, list it. Maybe you guys are talking about what you want to say under each of those factors. That's perfectly okay. Okay, then you just come back out. Continue. And, you can continue with the hearing. You can basically render a decision at that point if you want to. But use it to your advantage. Again, don't do it every time because you don't need to. But when you have that case where everybody's lawyered up, for heaven's sakes, I was in a BZA case in Delaware County where I think the janitor had an attorney. I'm not kidding. I've never seen so. I think there was like 5 of us in the room. The zoning inspector had an attorney, the BZA had their own attorney, the property owner had an attorney, 2 adjoining neighbors each had their own separate legal counsel. the property owner's father brought his legal counsel. It was crazy. I mean, there must have been $2,000 an hour in that room easy. American great.
For the attorney.
Can both boards do the deliberation? And it says that the zoning officer cannot be included in that, so
Yeah,
is
so
there
great
any?
question, and I'll get to the zoning commission. The answer for zoning commission is more than likely not. Okay, because remember, you got to figure out what role you're acting in when you're in the zoning commission. But if you're just rezoning property, the answer is absolutely not. Everything's got to be on the record. Only BZA can go into private deliberations. Okay, so the question becomes who the BZA can bring back into private deliberations with them. Did I say executive session? Legal counsel.
Who's legal counsel, theirs or?
No, not theirs. So, yeah, Chris and Mark and Vince and those guys, bring them back. Your special counsel, whoever you use, who there is with you that night, you could bring back with you. The question that we often get is, can the zoning inspector go back? Do you guys swear in the zoning inspector? Okay, so the answer should always be yes. So always swear your zoning inspector in. They're a witness. I would never have a zoning inspector go back. The only time I think maybe, in my opinion, would be a conditional use. But I think theoretically they're an adverse party. Right? And even, I mean, clearly they are an appeal, right? Because they've rendered a decision and then somebody's appealing their decision. But I've had that case and I've spent probably 3 hours researching the issue, probably spent another 2 or 3 hours writing a brief on it or a portion of a brief on it. So again, remove the roadblocks, no reason. So let's say someone has a question for the zoning inspector. Make a list, come out, ask the question. If you need to go back into private deliberations. Absolutely. I had one hearing, we went back 3 times. So, but don't give somebody that argument to make. So I don't have zoning inspectors go back. I've had it for conditional use, but the other 2, I wouldn't. Yes, sir.
Are you saying that the zoning inspector should be sworn in when the hearing is started?
Yes. Yep. So if you do a mass swearing in, make sure the zoning inspector raises the right hand. Gotta tell the truth. Yep. And you may ask why that's important. Remember I referenced the statute 2506? It has a list of things that BZAs have to do. If they don't do them, the applicant can supplement the record at the Court of Common Pleas. And one of them states that all testimony has to be given under oath. So if your zoning inspector is not sworn in, the first thing I'm going to do, if I don't like your decision, I'm going to appeal it. I'm going to get a second bite at the apple at the Court of Common Pleas. So because your transcript has said doesn't have the zoning inspector being sworn in. Yes, sir.
Should you have each person when they come up to speak, if you do a mass swearing in, then verify that they in fact were sworn in?
Yep. So if I do a mass swearing in, make sure that you get verification when they come to speak up at the podium. Absolutely. Do that. Yep. I'm not opposed to mass swearing in, but again, get confirmation. That's a good point. So that's kind of the role. So again, what do we hear when we're the BZA? Appeals, variances, conditional uses, extraction of minerals. Has anybody ever had that permit request yet? A variance or a conditional use certificate for extraction of minerals? I haven't done one yet. I would like to do one, so if you ever have one, call me up, I'll represent you for free. Just so I can say that I've got to do it, okay? So those are the, I wasn't on the road. So those are the four main ones. There was a fifth one that was added that dealt with surface mining. And that's contained in 519.141 of the statute. And it allows surface mining activities to be treated as conditional uses, but only if your code allows for it. That may be another area that you hear, but if your code doesn't provide for it, you know, you can't have it. So I always bring this up because I always make fun of clients that don't listen to me. I had a conditional use permit with conditions granted. The individual was not following the conditions. The zoning inspector had the BZA hold a hearing. During that hearing, the BZA came to the conclusion that they were going to revoke the conditional use permit. I told them, you cannot do that. They said, we don't care. I said, thank you. I have a son that's starting in Ohio State. I could use more money. And that's exactly what happened. You do not have the authority to revoke permits. Treat it as a zoning violation. So we actually went to the Court of Appeals on that case. And we lost. The court said, no, what are you doing? So just always bring that up. Appeals. So zoning inspector issues or denies permit. They make a determination on whether somebody needs a variance. They make a determination on whether something is or isn't agricultural. All those decisions can be appealed to the BZA. All right, and then the individual has 20 days to appeal that decision. I have in the materials, appeals may be taken by any person aggrieved. That's in quotes. Aggrieved is in quotes. That term is not defined in the statute. What I would tell you is that it's obviously the applicant. It's obviously a contiguous, adjacent, or directly across the street, any individual who owns property is going to have that. Once you get outside of that, there's an argument that that individual does not have standing. That's complicated. I've won a lot of cases on standing or lack thereof. But once you get outside of that perimeter, an individual is required to show special harm that is not unique to the community as a whole. So I had a gentleman who did not like a decision, and he was in a subdivision, the BZA granted a variance, and he appealed their decision, and he just didn't like the way it really looked. And he appealed it, and he was probably a quarter mile down the road. We got it kicked because he didn't have standing. So, but that's always difficult to sometimes to try to figure out. Board of Trustees, unless it involves township property, they don't have standing. Believe it or not. A lot of trustees sometimes don't like zoning inspectors' decisions. So imagine that. HOAs is another one that we get a lot. Typically, what I would tell you, an HOA doesn't have standing. Again, now, if they have, maybe they have open space that they own and maintain that's next to it, or some other type of fact pattern. But the HOA itself, just simply because a lot is in that subdivision, doesn't give them standing. So, so when you get an application in, the statute says that the appeal has to be decided in a reasonable period of time. So there's nothing in the statute that says you have to have you have to have the hearing within 30 days. Your code may say something with that, with respect to that. And that's typically kind of the general rule of thumb I follow is, And I know all zoning departments have timelines in terms of submitting and things like that. Just be reasonable, but there is nothing in the statute, it just says a reasonable period of time. You are required to give 10 days notice to parties in interest. That term is not defined in the statute. Your code may put a distance requirement in there that says 350 feet or 500 feet. But again, what I will tell you is obviously the applicant gets it, contiguous, adjacent, directly across the street, are always going to get it. Anything outside of that is up to you. And so if you want to put a 250 foot requirement on, that's fine. Here's the downside for doing that. And I've seen codes where it's 1,000 feet. I think arguably you're giving somebody the ability, I think you may be creating standing. If you go outside, contiguous, adjacent, directly across the street. Why else would you send, why would you send me a notice? Anybody, I mean, why would you send somebody a notice 1,000 feet away? Or 500 feet? I mean, that's a real question I'm asking. Does anybody know why you would do that? What the intent behind it would be?
Safety concerns,
Yes,
depending on what it is.
right, safety concerns, but I think you think that that person's gonna be affected, right? So we're gonna give them notice. You think that they're different than somebody that's 1,001 foot away. So it goes back to that special harm argument. So I'm a big fan of limiting it to contiguous and adjacent directly across the street. I understand that trustees like everybody in the world now. But that's just me.
What do you feel about the signs that go out? So-
Yeah, people put signs up too. I mean, you can do that. I mean, I don't have a problem with that. A lot of places do that.
But it's not required. is it?
No, absolutely
I
not.
think so. All right. Thank you.
It goes back to one of those things where typically that's a political discussion. I often find. I see it more frequently for rezonings than BZAs, but I do have clients that do both. But it's not required by statute.
Does that change the standing argument that, hey, you notified the
Yeah,
public?
good question. I think that was a little bit different.
Yeah.
And we'll get into who you let speak during your hearing, your BZA hearing. And I think it goes to that, kind of that point. So that's kind of a appeal. Just be aware when you're a zoning inspector of sending multiple zoning violations. Because I think if you don't do it right, the 20-day clock could just start over again. Because remember, someone has 20 days to appeal your decision. So if I keep issuing multiple zoning violations, are you theoretically giving the individual another 20 days to appeal your decision? I'm not saying you don't send the nice letter and kind of the, why didn't you respond to me? And then maybe the third nasty letter. But at some point, you need to have a final zoning violation to make sure that 20 days happens. What that enables people to do, attorneys to do is, let's say I send a notice, somebody doesn't come in, doesn't call me. Well, your only option at that point is to take them to court, right? And enforce the code. There's case law out there that when a property owner shows up and says, well, hey, I have A, B, C defense, that they are unable to argue those defenses because they failed to exhaust their administrative remedies. The appropriate time to make those arguments was to the BZA. And because you didn't, you've waived those arguments.
Let me go back to a statement you just made about limiting who can testify. What happens is, let's say for an example, a Twinkie store wanted to open up on 23 and it's in front of a subdivision. Are you saying that nobody in that subdivision can testify or ask questions in regards to that?
I think, yeah, so Twinkie store, I love Twinkies. That's all I'm gonna be thinking about now, Jerry. And then a subdivision is behind it. So obviously, if it abuts, you're gonna get some property owners that are gonna have standing. The question is, let's say at the other end of the subdivision, only in the back, could be a mile away. I think, I'm not saying you do this, but I think legally, you can determine who has standing in your BZA hearings, and only allow those individuals to testify. It's difficult to do. My mentor, Don, was the chairman of the Bexley BZA for a number of years. And I used to, a couple of times, I just go and watch because it was like a surgeon. And, Bexley, they hate development. The old folks in Bexley hate growth. So there were all kinds of people showing up to every, McDonald's going in with a drive-through, for heaven's sakes. You thought the world was coming to an end. The room was packed. And Don grilled each and every person up there and said, you don't have standing. You're not able to testify. Sit down. Now, I'm not saying you do that, right? Because again, I don't know, I kind of believe township is a great form of government. You can go and bitch, Can you imagine like if a stop sign falls down, going to Columbus City Council saying, we're gonna put up a stop sign, you're not even gonna get in the door, right? You can do that at the township. So, but I think you have that ability to do that. My general advice is you don't limit testimony. You just take it. That answer the question?
Yeah.
Conditional uses, great. I really like conditional uses. You can put conditions on them. Make sure your conditions relate, and this goes with variances as well. Try to make sure it relates or has something to do with the actual application, and don't try to fix other problems that are not related to the application that may exist on the property. Make sure your codes use the words may grant a conditional use. Don't put based upon a finding shall grant. Use the word may. Be flexible. Variances is next. Two types: use and area. Use, right? If you're doing it right, you shouldn't be granting use variances. A use variance is really a backdoor rezoning, is really what it is. The case law is a little bit scattered, but on page 7 of the BZA materials, right in the middle, are 3 little, I, 2, 3, right there. Those are the standards. Now, I know your code may say the wording a little bit differently, but those are the 3 things that courts will look at. If they do not meet any one of those, according to the court, you should deny it. And the one that typically gets everybody is number 2, which is what they call the self-imposed hardship. So famous case, the Barlow family, Youngstown, owned property that was zoned commercial. They want to put a strip mall. Didn't have enough land. So they purchased property right next to it, zoned residential. They didn't have the votes on city council to rezone it. Well, it is Youngstown, so I'm assuming that they greased the wheels. Went to the I have a lot of law school friends. They went to the BZA, and BZA granted a use variance for the residential to allow the extension of the strip mall. The residents sued and won. The court said, you created your own hardship, self-imposed. So very rare. should you ever be granting use variances, what I will tell you is you have to allow people to come in and apply for them, right? You can't say, what are you doing, you crazy? You have to allow for it. There's a case out there where a township put no use variances are permitted, and that got struck down. You have to allow for it. More than likely, you shouldn't be granting. It's probably more than likely appropriate for rezoning. Okay, that's use variance. Area variance is a lesser standard. The impacts to the property are not as significant. And there are two districts in the state of Ohio, two Court of Appeals districts that do not follow the Duncan v. Middlefield standard. They still fall under the use variance standard, because that used to be the law for all variances until the Supreme Court stepped in the Duncan v. Middlefield case, so we call it the Duncan factors, and said, this is really unfair. You know, if the impact is not that much when we're altering area requirements of zoning codes, we need to lessen the standard. So that's the test that they came up with, was the Duncan factor. It's a balancing test. You know, just because you don't meet one doesn't mean you deny it. You as an individual BZA member may weigh certain factors more than others. That's your right. You may feel that 3 or 4 is enough. They're actually, I was talking to an associate in the office who's researching the issue right now for a BZA, and she actually found a case, I haven't read it yet, that said that a BZA, the applicant only met 3 of the 7, and the court said that's good enough. I always like to tell people to get the 4, but she says there's a case out there that says 3 is enough, because the court has said that the testimonies from the BZA felt that those were the most important factors. And they significantly outweighed the other ones. The court upheld. So I like to get the 4. What I will tell you, you know, you can read through the factors there, but so whether a variance is substantial, what the case law typically holds is kind of 25%. A deviation of 25% or more is going to be substantial. But please, that's not the end of the analysis. Just because a variance is substantial doesn't mean that you ignore everything else. Okay? Sure, it's an important factor. That's not the end of the analysis. Okay? So that's BZA rule. That's what you're going to hear. I'm going to jump real quick to zoning commission, but does anybody have any questions? All right, well, zoning commission's not as exciting. I'm going to take a step back and go over zoning commission role again. So I think when you're acting on a modification of a development plan, right? Property's been rezoned, plan's been approved. Now the applicant's coming back and modifying something. So I think when you're modifying something, or you're involved in that second step of a PUD, a final development plan approval, you got the initial PD in place, preliminary development plan in place, now you're at a final development plan. Under those 2 factors, I think you need to act more like the BZA. Because it's not legislative at that point. And mostly what we do as a zoning commission is rezoning. That's to a standard district. Maybe we're floating the overlay cloud. Maybe we're rezoning to an initial PD. That is legislative. You are acting as a legislator. So the rules of the game are different. right? So I'm talking about zoning commission and the trustees, so I'm gonna group them together. That decision is not subject to a direct appeal, but it is subject to referendum. When I'm acting in a legislative capacity, subject to referendum. It means that I can have ex parte communication with applicants, developers. I'm not telling you to violate the sunshine law, okay? Right, but if I'm the chairman and the developer picks up the phone, says, hey Pete, what do you think about this plan? There is nothing illegal about that. You can do that. Now, I tell people all the time, I share the example, again, you're a legislator. So, you know, on this solar farm thing, when Heidi and I went down to the State House, we met with a couple of legislators down there. I mean, that's what you do. It wasn't in a public hearing. Now, you may personally have a problem with doing that, and I'm fine with that. Right? You have to decide for yourself as a zoning commission member and a trustee whether or not you want to take those meetings with individual applicants. Completely up with you. Completely up to you on what you want to do. I know a lot of people won't. But I tell you, the really good developers, they know their vote before the hearing starts. Now, I mean good, like, you know, good from the dark side type of good, right? You know, evil empire. They know the votes. They got the vote count. But again, you decide as an individual member whether you want to do that. And I have a lot of folks that say, you know what, Pete, I'd just rather not, and that's fine. I have a very large developer in Central Ohio, big corporation, and some of you have had lots of dealings with this individual who are typically is involved in their applications. And I have one trustee that refuses to meet with him, and it drives him crazy. It just drives him crazy. I get the biggest kick out of it. Because the other ones do, and then all the zoning commission members do, and he'll pick up. Why, does she have something personal against me? And I usually mess with them and say, I think so. And I just, you know, again, it's her decision. She doesn't want to. She wants everything to be done, you know, she'll communicate with her staff on rezoning, right? So, up to you. But it's okay. Your hearing, right? We don't have to run it like a civil trial like the BZA. We have a little more flexibility, okay? If we don't do something, maybe right, not a big deal. We're okay. And part of that is because you can't appeal our decision. Private deliberations. I know this question was asked earlier. It's a big no-no. Can't do it. There's no executive session. When you're all together as a group, everything's got to be on the record. You can't go back and say, well, should we ask them for just a little bit more of a reduction in density? You can't do it. You can ask for it on the record. You can't game plan behind the scenes. So comp plans, I have a bunch of case law in here. I mean, and I don't mean this, oh, go ahead, sorry.
Real quick, with the zoning commission hearings, what's your perspective on live streaming zoning hearings, like on Township Channel, like YouTube or something like that?
So live streaming zoning commission, I think it was, well, I actually hated it. I liked it in the sense that I could sit in my PJs with a dress shirt on in my house, and we had the hearing and everything. It was great in the hearing. But it drove a lot of people out of the woodwork. It was much easier for people just to get online and complain. Moving forward, now that we no longer have the ability to conduct electronic meetings under the law, I think you can stream it, but you should not be taking testimony remotely. Or the chat room, turn that off. That's trouble. One of the lawsuits that we're involved in, public record request was made for all the comments the residents were making. on the Facebook page. Right, and those things are relevant, because residents get nasty. And I don't know if you've experienced it, but I've experienced it. People are mean today, they really are. And some of those statements, bad facts make bad law. And, so those could be used against you, so turn them off. Don't answer questions. I had one township answering questions, like during the hearing, like, why are you answering questions? Don't do that. So, okay, to stream. I know for a long time, a lot of municipalities have always done that. They've streamed their meetings and things like that. You can do it, but don't definitely allow comment. Don't take testimony. Don't do any of that. Just allow the stream and that's it.
Is that just for hearings or for regular meetings?
I would say, and I haven't talked to Chris about it, but we don't have the ability to hold electronic meetings anymore. So what I'm telling people is that if someone wants to come in and talk to the township, they need to personally appear. But I don't, there's an AG opinion that was kind of pre-pandemic that wasn't really friendly in terms of allowing for electronic communication. I say no, but I think everybody's got to come. You could stream your trustees meetings, but I think everybody should show up. And how you control that environment, I think you can control it. I think those AG opinions allow you to control it within reason. So if you're space limited, it's no different than, it's no different than the fire code. If the Delaware County Board of Health saying 6 feet apart or whatever, you can implement those type of requirements. You're just gonna have to learn how to shuffle people in and out. Comp plans, I got a bunch, and I don't mean this as a brag, but I don't think there's anybody who's been involved in more comprehensive plan lawsuits, Supreme Court cases in our office. We've probably had 5 times we've been to the Supreme Court. So I'm just gonna kind of generally, I don't want to bore you with all the detail, I just want to give you kind of takeaways on comp plans. Your text and your map are enough under the law to constitute a comprehensive plan. Your text and your zoning map are enough under the law. The only cases that I've seen where that's not the case is where a township has a zoning resolution and a map, and everything on the map is zoned agriculture. Everything. Which that's not the case here. You don't know. Text and map is enough. So you don't need a separate standalone comprehensive plan. Legally. Practically, you should have a standalone comprehensive plan. I'm a big fan of it. I think, Scott could probably tell you better. I've always heard every 5 to 6 years. I know people don't follow that rule, but you should be looking at every 5 to 6 years. Do we need to tweak this based upon growth? Your comprehensive plan is just a guide. It's a good guide, but it's just a guide. So your decision does not have to match, legally does not have to match what your comprehensive plan says, legally. Should it? Well, that depends. What's your reason? Let's say I haven't updated my comp plan in 15 years. At the time the comp plan was made, there were no centralized utilities to that site. Now there is. Probably a pretty good reason to deviate from the comp plan. Have a basis for doing it. But if your comp plan called for it, then that's your crutch, right? Fall back on it as your basis of your decision, whether that's a good thing or that's an approval or that's a denial. if there's a conflict between your comprehensive plan and your zoning resolution, the zoning resolution controls. The zoning resolution is the law. Comprehensive plan to go. Again, and I've gotten into this conversation recently with a couple of overlays about, we have a comprehensive plan and the code has not been, or the comprehensive plan has not been updated in some time, say 10 years. I take the position that I can use an overlay as almost like a mini comprehensive plan update for a certain area. And I could float the overlay. Is everybody aware of overlays? Rather than redoing a whole full-blown comprehensive plan update, I can basically decide, I kind of want to steer or incentivize a certain area, and this is kind of what I want to see in this area. Since I don't want to use anybody in the room, we'll talk about the one in Jerome Township. So the southwest portion of Jerome Township, which goes to 161 all the way up to 42 along 33. We are creating an overlay, called the Innovative Business District Overlay. And we float that cloud. This is everything we want to see. And it's got a whole bunch of hodgepodge uses. It's everything we want to see or incentivize. All the uses, all the standards, and we're going to float that cloud. This is our vision for this area. It's not a comprehensive plan update. It's just an overlay. It's a PUD overlay. You float that cloud. Same process, 51912 process, float the cloud. Right, and then at the underlying property owner's application, they could come in and pull that cloud down on their property. I think overlays are a great mini comprehensive plan update. And a lot of people use them for economic development purposes. There is no statute in the higher revised code that says how you update your comp plan. I think consistently, I know we've talked to Chris about this, and I think they're kind of the same opinion that we kind of follow the 51912 rezoning process. Kind of, get it to the zoning commission and hold some meetings on it, and then zoning commission makes a recommendation. You get Scott's input, he may be going to help you do it, and then send it up to the trustees, and the trustees approve it. So it's not you don't have to meet all the requirements of 51912, but that's kind of the process that most people will use. It's kind of that similar process. So that's comprehensive plans. Zoning amendments. I have a bunch of stuff in here. Get this to staff, your zoning inspector. And I'm not gonna go through all this because I really want to get to the hearing part. But just understand from a staff perspective, with respect to legal notices, there's a difference between when you are rezoning 10 parcels or less. If you're doing that, you're required prior to the zoning commission hearing to send out first-class mail to contiguous and adjacent property owners. And then in addition to whoever else you have in your code. And there's a list of 7 things that your legal notice has to say. So whenever I'm involved in a really big rezoning or whatever, and I write these things, or when I get stuff from staff that I'm double checking, I check off. I read the legal notice and check these off. This is page 8 of the zoning commission. This is everything that needs to be in there.
I think I can make it a little bit easier.
Yeah.
We actually have forms
There you go.
for both the zoning commission and the trustees for the notices that they need to give, whether it's under 10 parcels or above 10 parcels. It's literally done as a checklist.
Yeah.
If you want to see them, They're in the back of the prosecutor's township officials training manual in the form. But, you know, and you can always ask for the form.
Yeah.
That's fine. But I think it makes it easier because it literally has the check line
Yeah.
on it. So you can go through and check it off and make
Yep.
sure you have it when you notice. It's super easy.
Yeah, so make sure you have that, and do it every time. It takes 5 minutes. And run through that checklist. And by the way, the prosecutor's training is coming up in
The very beginning of December, December 4th.
December 4th, so if you haven't seen it yet, keep an eye out for it. But that's the checklist. Both numbers are in there for 10 or fewer. And then it's slightly different if you're doing a text amendment or more than 10. But you're not required to send notice out.
That form also has the publication requirements on it too.
Yeah.
So
Sorry, I just have one quick follow-up question
Sure.
about the club. While it is just a guide and your decision does not need to be made based on it, if your rationale is in accordance with the club, does that hold legal standing? So if you deny an application and you say, because it doesn't line with the club, that holds weight in court?
Yeah, so Violet Township, Fairfield County. Developer came in, filed for rezoning, to PD, development plan, met the comprehensive plan, met all the general requirements of the code, checked every single box, trustees denied it. They're in federal court right now. The first thing that they argued was that it was a comprehensive plan. There was no basis to deny.
And then the opposite way is true.
Exactly right. So I say it's just a guide, but it's, I should say it's a strong guide. I mean, you know, use it to your advantage. But if you're gonna deviate from it, you should have a good reason to deviate. It's a great point. So again, you have the stuff in there. The one question I get a lot is, once the zoning commission makes a recommendation to the trustees, how quickly do the trustees, you know, what's the process? How quickly do the trustees have to set it for hearing? You know, the statute actually doesn't provide a time frame for when the zoning commission makes a recommendation. The only other thing it says is that trustees shall receive that recommendation. And upon receipt, they have to set it for a public hearing within 30 days. So I typically have, you know, whenever the zoning commission makes the recommendation and you know, the paperwork's ready, at that next regularly scheduled trustee meeting, I typically have the trustees receipt it and set it for a public hearing. You know, but there is no time frame. Now, if I really want to move something through quickly, I've had the zoning commission render a recommendation, let's say on the 1st, and the trustees have already called a special meeting on the 2nd to receipt it and set the hearing to meet the statute. Just don't play a game with that. I mean, I wouldn't let it go too long. And like I said, as a general thumb, usually, because I don't know, do you have people that just do it administratively? Where the trustees actually don't formally receipt it, or?
there may be some that I'm just not aware of.
Yeah.
But I would recommend seeing it.
Yeah. So I just want to bring that up.